Morning Talk with Siki Mgabadeli.
It is at 24 minutes to 11, and we're moving on now, talking about the protection of personal information. A bill that's set to have a widespread and significant impact on the country as a whole. It imposes 8 information protection principles on all companies and public bodies that process personal information. So this morning, getting an understanding of the bill and what its impact is likely to be. And you can call us on 0891104207, SMSs to 34701. My guest this morning, Dani Strachman, who is an attorney partner at Adams and Adams. Dani, good morning.
Good morning. How are you?
I'm well, thanks. And you?
Good, thank you.
What is the purpose of the Protection of Personal Information Bill?
The whole purpose of this bill is to protect, as the name says, personal information. Now, there's been a couple of acts that came into force recently, well, actually over the past, let's say, decade. There was the Consumer Protection Act that we had last year, which protects consumers in their business relationships with suppliers to make sure that they be dealt with on an equal footing. And then we also had the National Credit Act before that, which assists consumers in the credit sphere when they get debt to make sure that's regulated properly. Now, this is sort of a third pillar there to protect consumers, but it goes actually much wider. It protects all individuals, their personal information, how it's processed, how it can be stored, how it can be collected, what people can do with it. So as the name says, it protects people's data.
How do you define personal information in this current open environment where I suppose everything personal is being redefined, I've noticed?
That's a very good question, because if you look at the definition in the Act, it's as far and as wide as the ocean. It's anything from your name, your ID number, your postal address, up to literally your biometric info. In other words, your retina scan, your blood type, anything that I can identify you in that perspective. It even includes your opinions and your preferences. So the fact that I like cheese is personal information.
So if I put that out on Twitter and somebody goes and sells it to someone, then they're in trouble.
No, you see, that's the point. So if someone has the info about you, so if they know your personal preference, what kind of wine you like or whatever, they must actually make sure that they process that in accordance with the bill's provisions. Now, obviously, there are limited exclusions. So the processing of personal information in a personal context. So if I share over a cup of tea with a friend that I like cheese, that's obviously not regulated by the Act. That's just a personal interaction. But in a wider context, the Act will apply. So it's quite interesting how far it goes.
What sort of abuses is this trying to deal with, on a serious level?
I think it's about time that we have something like this. It's obviously quite heavy legislation for the market to take in, I think. But it's focused at situations like your ID number being abused because someone is careless. The ID number gets into the hands of criminal and they conduct fraudulent transactions or open a fraudulent account under your name. And also, obviously, your personal information. And if you look at there are specific kinds of special personal information that the Act talks about. So your religious information, sexual information, health information. Children, in fact, are sort of elevated to sort of even a higher category. So any kind of information about children must be dealt with in a very special manner. So it's aimed at abuses of personal information where in the past, information would just leak out about someone, or it would be abused for criminal purposes.
And we'll talk about the 8 information protection principles, but I think it was in last week's open line where we had a couple of callers complaining about our cell phone companies having, the whole WASP thing, where you land up with money coming off your account for a service that you had not actually signed up for. Would this fall under this potentially?
The closest that this bill gets to it, or let me maybe explain to you, direct marketing is probably what that is aimed at. So we get these cell phone companies that contact you with info that you didn't want. That kind of situation is dealt with in this bill, also in the Consumer Protection Act, that also regulates direct marketing. But that kind of scenario, in other words, where a service provider gives you a service that you don't want or that you asked for initially and you didn't want anymore and you're now paying for it, that would not be regulated by this Act. That would be either in the Consumer Protection Act or the Electronic Communications and Transactions Act, and then also in the Industry Code, the WASPA Code, and also the ISP Code.
Okay, so that would fall under a different...
Yes, the closest that this gets to commercial sort of scenarios is the regulation of direct marketing. So if you're sending commercial communications, spam emails, spam SMSs, cold calling, that is still regulated by this Act. But the foundation of this Act is personal information and how that can be dealt with.
So if, let's take an example of a service provider who I have dealings with, passing on my information to another service provider without my knowledge, and that's my personal information of, the selling of databases that has been going on for many years, for example, would that fall under the ambit?
Exactly. That's specifically one of the things that this Act is trying to regulate. Just while we're saying that, remember this is still a bill.
Yes.
So the bill has been approved by the National Assembly. I think that happened in the second week of September. It's now being referred to the National Council of Provinces. If they then approve it, then it will go to the President for signature, and then it will be enacted. So this, whatever we're saying and discussing now, is still draft legislation, because it could be changed by the National Council of Provinces, and then it will be referred back to the National Assembly, or for further drafting. And that's quite probable. That often happens with legislation, especially something as deep and broad as this kind of legislation. But yes, that will specifically regulate databases. In fact, I think most marketing companies or any kind of business that uses some kind of database, be it a written database that they somewhere have in a black book or an Excel spreadsheet or something that they have in some kind of software, all those databases will basically have to be reviewed. Because if you think about it, I spoke to a marketer just the other day, and she's been compiling her database over the course of about 10 years. She doesn't even really know where all those names come from, and whether the people that gave her those details even knew what she was going to be using it for. So, and a lot of these companies do use these databases. They sort of do the rounds. No one really knows where they come from. Some people buy them, and I've even spoken to people who've been in that situation where they've been offered the right to buy a database. It contains 10,000 people, and they make big statements about what the database is worth. But can they give you the guarantee? So if I'm now a small business and I want to expand and start marketing to people in my area, it's much easier to just buy a database and then immediately get wide exposure. But I'm taking a risk because I don't know whether all those names and contact details on the database are legitimate, whether they've been obtained legally. And when this Act comes into force, there will be a duty on you basically to check and refresh your whole database and make sure that the people who are listed on there gave their consent for you to be able to contact them, and then also whether the information was in any event obtained in a legal manner.
Yeah, all right. We're going to take calls on this one as well on 0891 104 207, 0891 104 207, SMSs to 34701. How do you think the way that our personal information is used, is distributed, should be regulated? And what do you make of the proposals of the Protection of Personal Information Bill? I'm in conversation with Dani Strachan, who is an attorney partner at Adams & Adams.
Morning Talk with Siki Mgabadeli.
14 minutes at 2:11 here on SAFM 104 to 107, talking about the Protection of Personal Information Bill this morning in conversation with Dani Strachan, who's an attorney and an attorney partner at Adams & Adams. So, what would a perfect bill for you? If you look at the current version of the bill that's going through that's going through Parliament and the NCOP at the moment, do you think it's the best way to regulate this, Dani?
It's definitely international industry standard to regulate the processing of personal information in this manner. This bill definitely draws also from similar kinds of legislation that you'll find in Europe and also in New Zealand, Australia. So once we have this as an act, it will definitely be on par with what's happening internationally. In fact, it's quite high up there when you compare it to other countries' legislation. And the problem just with all kinds of regulation is always that you can have a model piece of legislation that is 500 pages long and regulates every little aspect. Unfortunately, in the end, it will depend on how this is enforced. So the bill makes provision for the information protection regulator that will be established. So it's going to be a new, basically, government office, and they will look at whether people are complying with the act. They'll advise government on the protection of personal information and update them and make recommendations. And then there's also the enforcement committee. So if there are contraventions of this act or breaches of some of the provisions, then that can be investigated, and the enforcement committee will take decisions on that. But ultimately, one will actually see when this is now law whether the regulator will do its job, whether people will comply with this bill, whether, and I think, and unfortunately, sometimes it's also about the stick. Will businesses be scared because they see these penalties being dished out, handed out to suppliers and to businesses that don't comply? And one can obviously compare it, I suppose, with other pieces of similar kinds of legislation, and they were seeing varying results. Some of the regulators are doing a sterling job. Some of the regulators, I'm told, not that much of a good job. So it will depend in practice, but it's definitely that's how it can be done, and that's internationally how it is done.
Now, I understand that it's going to also establish an information protection regulator. What would that person's role or that office's role be?
Is that will be it's similar to something like the Human Rights Commission or any of the other bodies that regulate certain pieces of legislation. And the regulator will be there to inform the public about their rights. The regulator will look at what's happening in the industry. They'll advise government if changes need to be made. And they'll also play the enforcement role, which I think is probably the most important part if you're a person who has personal information. So the regulator will then receive complaints from people if their information is not treated properly or in line with the Act. And then they will investigate that, and if they find that the complaint is valid, then they can issue infringement notices if there's an offence, but they can also issue other kinds of compliance notices forcing basically the person who's dealing with the personal information to deal with that properly.
I mean, I mentioned how the open nature and the pervasiveness of just the ease with which information is passed on between different people, different countries. What happens then if a foreign entity wants access to my personal information or has access to my personal information? Does this apply to them?
Exactly. That's one of the interesting parts of this bill. It says it regulates and it calls that the cross-border transfer of personal information. So it deals on both sides of the border with the situation, basically. So if I'm a business in South Africa and I'm transferring personal information across the border, and that can happen in various instances. The typical thing that happens is people have servers or storage facilities outside the country. So you can't then just transfer that personal information across the border anymore unless it complies with the bill. Now, to the big situations where that will comply is if the person to whom the information belongs consents to that, or otherwise if that country has proper personal information legislation that's similar or better to our legislation. So you can't just transfer it across the border anymore once this act is in force.
And that would apply also to foreign businesses operating in South Africa, because they would need to work within the legal framework in this country.
That's right, and a lot of these foreign businesses, I'm already dealing with a number of queries from international clients that are getting concerned about this, and they're probably not, and it's also a different attitude sometimes, I think, from their side, because they're already used to this. So we often, and in the past years, we'd often receive a questionnaire from a big business overseas saying, tell me about your data protection legislation, and then we would come back and say, well, there's nothing really, and they would be amazed. But now we have something. So if I'm a foreign business and I'm doing business in South Africa, I still have to comply with what is happening here. Yes.
And these 8 actual information protection principles, let's maybe go through what they are and what they imply.
Yes. The first, there's 8, so it's quite a long list. The first one is accountability. Now, that is actually a very nice condition if you think about it, because it says that if you're dealing with someone's personal information, you have to be accountable to that person. So it puts a bit of responsibility on a responsible person's shoulders. And I mentioned responsible person there. The Act defines a person who processes personal information as a responsible person. So I'll keep on talking about that. It's a processing body, basically. So they have to make sure that if they process personal information, that it's in accordance with the bill's requirements. So it's sort of the overarching kind of condition, because it says that you can't process personal information unless you do it properly and in accordance with the bill. Now, the second condition is that's the processing limitation, which that's how they call it. It basically says that if you process personal information, it must be lawful, so it can't be for illegal purposes, and it must, again, be in the framework of the Act. There's a minimality concept under that also, so it limits your processing to something that you have a lawful purpose for. So you can't just process all information about a person. So if I want to open an account at a video store, they don't really need to know what my DNA code is or my blood type, because that's not relevant. And they're entitled to the minimum kind of information. And then obviously they need consent, so you can only process personal information if there's consent. And also what is quite interesting, the information must be limited to information collected personally from the person. So that is quite interesting. So if I collect information, I must actually collect it from you, if it's your information that I'm collecting. Then the third one is purpose specification. So I can't just willy-nilly process personal information. I must have a purpose for that, and that must again be a lawful purpose. And then what is also related to that is it also regulates how long I can store the information for. So if I'm collecting personal information for a specific purpose, to, let's say, open an account, I can't keep that for 10 years because that's not relevant, and there's no reason why I should keep it for that long. The fourth condition, can I carry on? Or
No. What I wanted to just touch on with that, with the purpose, is for the actual consumer or the citizen, do I have a right to ask what my information will be used for? Is that right protected in that?
Exactly. And that's actually one of the principles, one of the further conditions, data subject participation. So I do have a right to firstly ask someone why they want my personal information. I can also ask them, do you have my personal information? What do you have on me? And then it even goes further and say, if you have information on me, I want you to delete it.
Oh.
Yes, you in fact have the right to ask them, to force them to update your personal information. And there's an ongoing duty, in fact, on processing parties or responsible persons to make sure that the information that they have on a person is current. Now, let's go back to those databases again, those 10-year-old or 20-year-old databases.
Ones,
There's a mission lying ahead for some people out there.
I don't even want to be them. Because now imagine you got the wrong phone number, wrong address of this person, and you have to start from scratch.
And now the good question is, and it's also related, which I'll touch on now. But if the information is outdated to such an extent that you can actually not get hold of that person, you'll probably just have to delete it, because how will you then update it or make sure it's accurate?
So that you are
cell phone
compliant.
number has changed, for instance, or the street address. Now, and the other reason why that is also quite interesting is that if you store personal information on a person and that information gets disclosed somehow, so it's stored on my cell phone and my cell phone gets stolen, or it's in a little book in my briefcase and that gets stolen, or I leave it somewhere and now it's out there, I actually have a duty to inform all the people to whom that personal information relates, that the information has now been disclosed. Now, there's the irony again. If you don't have a backup of that copy, so if it's your own little address book and you don't have another one, how will you actually be able to inform all those people that their personal information is now at risk because it's somewhere out there in the hands of a criminal or lying outside there on a table?
No. Donnie, how is this going to be policed?
That is the information protection regulator's job. So they will check compliance. They'll receive complaints, and then in certain instances they can also then refer to the police services, to the SAPS. So there are certain the serious provisions of this act come with sanctions, criminal offences. And if persons breach those provisions, then the information protection regulator could refer it to the police. But there are sort of less serious provisions in the Act that can be dealt with by the information regulator, and they can issue notices to make you comply if you're not complying with the bill, and they can also issue penalties, and the penalties can be up to 10 million rand.
That's deep.
Mm.
That's very steep.
And also present term, of course, for some of these some of these offences 12 months, and some of the others it can actually go longer than up to about 10 years.
Yeah, I mean, I suppose it will depend on the nature of the offence
exactly.
and how serious
so
it
let's
is.
see what happened, why it happened, whether the person maybe had a defence or reason why something happened. But at least it's out there. So if you get careless companies that just deal with information how they please, at least it will be possible to take them to task.
Do you feel that companies are readying themselves for this upcoming potential piece of legislation?
Yes, and no.
Yes and no.
It's a typical kind of scenario that you normally get. Some of the good corporate citizens and many of the international companies are already looking into this, trying to attend seminars, conferences. I'm in fact today speaking at another conference about this. So there's definitely people are putting their feelers out to find out what this is about and to start getting their houses in order. But then you'll also get lots of other businesses that will just say, well, let's just wait and see when it's an act. But some other people will say, well, let's wait until it's an act and people get severe fines, and then we'll do something about it. So unfortunately, as with all things in life, it's an attitude, and some businesses have the right attitude and they see this as a positive, because there are, in fact, benefits to this legislation, even for businesses.
Yeah.
If you think about it, if you now have a duty to update your database, at least then you get to know your client again. At least you know that your information is current. And if you go through this exercise, you can, if you're a marketing company or any kind of business, you'll have the opportunity of maybe getting new software to organize your data and find out what kind of information you do have on people, and you can maybe use that for your benefit again. So, and some businesses are actually going through that. They're compiling checklists to start seeing what kind of personal information they're dealing with, who is responsible in their organization. So, appoint someone in admin or HR or finance to take on this task and be the champion of personal information regulation in their organization.
And we talked a little bit about those companies that their business is marketing, their business is around databases, but this will affect everybody basically who's holding any form of personal information, right?
Anybody and everyone, yes. So that's why I said, whereas the National Credit Act and the Consumer Protection Act mostly relates to consumer kind of scenarios, so either debt or normal business kind of commerce and retail. This bill goes much further. It even, and this is quite interesting, it even covers personal information of companies and CCs and trusts and partnerships. So at least if you're a business, your information will also be kept confidential, because if you think about it, even that kind of information is abused. Small businesses get targeted, loan sharks and what have you. So anyone that is dealing with personal information will have to check how they're dealing with it. So people shouldn't just sit back and think, oh, well, I don't do direct marketing, I don't do telemarketing, I don't deal with
so it's got
customers
nothing
at all,
to do with me.
I don't have to worry. But anyone that has account information, if you think about it, even a bowls club or a tennis club has a list of members, and that list contains personal information about people that needs to be processed accurately. Religious organizations, schools, definitely hospitals, all those kinds of institutions deal with personal information in one way or another.
All right. Donnie, thanks so much for your time this morning.
It's a pleasure. Nice talking to you.
It's been great talking to you. Donnie Strachman is an attorney partner at Adams and Adams.